Hello, and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is a collaboration with our trusted partner, eDiscovery Today, now in its sixth season. Today's webinar is titled Important eDiscovery Case Law Decisions for October 2025. Our faculty experts are Doug Austin, Tom O'Connor, the Honorable Judge Andrew Peck, and myself. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar. This webinar will be available for replay at your convenience for the next quarter, as will all of our EDRM webinars. Slides will also be available after the webinar. Holly Robinson, EDRM's Senior Marketing Operations Manager, is here. Please tell us what resources are available today, Holly.
Thanks, Mary. And we are loving On24 with so many ways for you to engage. If you look at the bottom of your screen, you'll see the console. The question mark icon is where you can type in your questions for today's faculty, and we highly encourage you to do so. You'll also see the paperclip icon. If you click on it, you'll find today's resources. You can download the On24 engagement tool descriptions to help you better engage with the platform. There's a link to subscribe to eDiscovery Today blog, an excellent way to stay informed every day. You'll also find a link to learn more about the Honorable Judge Peck and how you can engage with him. Right below that, there's a link to get your copy of the new book from Tom O'Connor and NextPoint, Artificial Intelligence for the Rest of Us, which is their latest project following their earlier collaboration, eDiscovery for the Rest of Us, the Checklist Manifesto. You'll also see a registration link for next month's case law webinar, Important eDiscovery Case Law Decisions for November, happening November 17th, and we'd love to have you join us again. And be sure to register for our upcoming webinar tomorrow, Building a Resilient and Repeatable White-Collar Investigation Playbook. If you'd like to learn more about today's faculty, click on the speaker bios and they'll pop open with more details about our presenters. And just like on Zoom, you'll see the smiley face emoji and lots of other reactions, and we highly encourage you to use them. Finally, click the Twitter bird icon to follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Holly. And all opinions expressed here are faculty's own, not those of their firms or clients, and no legal advice is being provided. And today's faculty, as always, Doug Austin, editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Doug is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving the J.D. Supra Reader's Choice Award as a top eDiscovery author and a top cybersecurity author. Doug has presented at numerous webcasts, events, and the best conferences. We also have with us Tom O'Connor, director of the Gulf Coast Legal Technology Center. Tom O is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in the complex litigation matters, where he's worked with firms of all sizes, including the plaintiffs in the BP litigation. He's also been appointed as technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. Tom also hosts with Rocky Messing the eDiscovery channel on YouTube, and he's updated and redone a wonderful book, and Holly read that out. It's in your resources, The Artificial Intelligence for the Rest of Us. The Honorable Judge Andrew Peck, Senior Counsel at DLA Piper, is a Band 1 Chambers ranked Senior Counsel at DLA Piper, serving 23 years as a United States Magistrate Judge for the Southern District of New York. Before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters, with extensive trial experience. And at DLA, Judge Peck advises on those copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues, information governance, and cross-border discovery from a judge's perspective. Sought out as a conference speaker concerning eDiscovery issues, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. And EDRM is very grateful to all three of these wonderful men for their service on the EDRM Global Advisory Council. And Doug, do we have some cases today?
We do indeed, Mary. Thanks, and welcome everybody to our October case law webinar on the EDRM network. We do indeed have 6 unique cases to discuss this month, and those cases address disputes related to non-party production of AI training data and documents, sanctions for a glitch in Microsoft Purview, sanctions for a glitch in a third-party archiving solution for M365, dispute over clawbacks under a 502D order, a request for an ESI stipulation order, and email threading to reduce the volume of emails for review and production. Of course, we do welcome questions, and we'll try to get to as many as we can, and we'll send out a copy of the slides after the presentation, so look for that too. As Mary pointed out, of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. That's true even when there's a technical glitch within our purview. And here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. Minerva 26 has over 44,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. This first case relates to an issue we're seeing more and more, the use of copyright works to train large language models. In this case, the plaintiff served Microsoft with a subpoena seeking 2 categories of documents: executed licensing agreements for AI training data and all documents and communications related to licensing books for AI training purposes. Microsoft had no problem with the first request, producing its executed agreements, but objected to the second. It argued that the plaintiff's request for all documents and communications was irrelevant, overbroad, and burdensome. To lessen the burden on Microsoft, plaintiffs offered to limit the scope of their request to Microsoft's documents that it had already produced in the ongoing NRA OpenAI MDL, but Microsoft noted that this compromise would not sufficiently relieve the burden of production because they would still have to search through the over 200,000 documents they produced in the MDL to find documents responsive to RFP number 2, and that production would require them to produce confidential business information and communications with third parties unrelated to this litigation. As California Magistrate Judge Lisa Cisneros stated, finding that documents relating to the licensing market are not relevant at this point in litigation would prematurely foreclose plaintiffs' ability to advance their claim and shift what is likely a central issue in this case from resolution at summary judgment to a definitive resolution through a discovery dispute. She also added, for purposes of discovery, relevance is defined broadly. Relevant information for purposes of discovery is information reasonably calculated to lead to the discovery of admissible evidence. But she also said, the undersigned is cognizant that Microsoft as a non-party is afforded additional protection against overbroad discovery requests. Requests to non-parties should be narrowly drawn to meet specific needs for information. So how did she balance the two? Judge Cisneros narrowed the subpoena as follows. The court declines to order Microsoft to produce all documents and communications related to licensing books for use as AI training data. Instead, the undersigned modifies the subpoena to limit Microsoft's production to its communications with and documents regarding the entities with which it entered into licensing agreements for AI training data, where the communications or documents indicate potential or proposed terms for licensing. She also ruled that the materials were to be designated highly confidential, attorney's eyes only, offering protection for Microsoft and third-party partners. So, Tom, given that Judge Cisneros stated that relevance is defined broadly, but also said requests to non-parties should be narrowly drawn to meet specific needs for information, do you think she managed to accomplish both with her ruling?
Well, yeah, I think so. I mean, she, you laid it out pretty clearly here. She talked about what the general rule is, but then, went into the issue that non-parties are, as she said, quote, afforded additional protection against overbroad discovery requests. And then she talked specifically about what she was going to allow for Microsoft, some specific documents, but modified the subpoena specifically to the entities with the licensing agreements, where there was some potential or proposed terms for licensing. And I like the fact that she said, additionally, they're going to be designated as confidential attorneys' eyes only to give them some additional protection. So, yeah, I thought she did a good job.
Yeah, and I think it's becoming more and more common to have those designations for groups of documents like this, because they're, the highly sensitive documents are out there in litigation a lot. So,
yep.
Couldn't agree more. So, Judge Peck, given the 2015 rules changes regarding proportionality, should judges still use the phrase reasonably calculated to lead to the discovery of admissible evidence?
Unfortunately, judges, even judges like Judge Cisneros, who's pretty up to speed on eDiscovery issues, but everybody's got to learn to read the rules as currently written, and the reasonably calculated language got removed during the 2015 amendments. And so it should not be a phrase used by lawyers or judges. Similarly, lawyers and judges should not use pre-2015 cases in discussing issues about discovery under Rule 26 and the other discovery rules, because the rules changed significantly in 2015. So, that's an oopsie on Judge Cisneros there.
Yeah, and a surprising one, because like you said, she is very up on eDiscovery issues, and she's had a lot of terrific rulings in the NRA Uber case. So, as Tom would say, read the rules shankopotamus, because that's one of the...
Well, I was not going to say that about another judge. I left that to
You left that to me, Tom.
That's exactly right.
There you
That's
go.
Exactly right.
Well, there we go. Well, it's said amongst the group here. We can leave it at that. So, Mary, do you think that Microsoft overstated the burden of producing from the documents that it's produced in the NRA Open AI MDL, or do you think it should have been relatively simple to perform a subset production from those same documents?
Well, it would be simple to do a subset production if you just wanted to produce everything without looking at it. But they were asking for things that were not even finished business deals. So I think what the judge did in hanging her hat on the executed licensing agreements and then the communications around those things, that's a finite universe. You can make a good search. If without those finite edges, you're either producing everything or you've got to figure out how far in the sales cycle or the negotiation cycle are you, and what the communications would be voluminous. So, being a non-party and having those extra protections, I think Microsoft's team did a good job in slicing that up.
Yeah, agreed. Yeah, and definitely would expect to see more cases like this and more kind of nuances on what falls within a non-party's production scope. So, interesting case, and we'll move on to the next case. And I mean, let's face it, we've covered our next case so much that my colleagues will be delighted to know that I'm almost out of basketball puns. In the very busy Oakley v. MSG Networks case, Oakley alleged that MSG intentionally destroyed or negligently failed to preserve corporate emails from 11 current and former employees who were involved in his removal from the arena. Oakley argued that MSG's explanation of a systemic technical glitch was unconvincing and that the loss of data pointed to selective preservation with nefarious intent. He proposed theories of deliberate deletion, including the use of a computer program called PowerShell for a mass simultaneous change. MSG countered that with facts that included that they issued the first legal hold notice 9 days after the incident occurred, that they implemented a technical legal hold through Microsoft's Purview software, which was designed to override normal deletion protocols, that the loss of emails was due to a systemic technical glitch within Purview that was beyond MSG's control. I guess you could call that a technical foul. Okay, maybe I have one pun left.
Yeah.
Come on, that was good. And that Oakley was not prejudiced, as each of the custodians submitted sworn declarations stating they did not recall sending or receiving any emails regarding the specific physical force or statements made to Oakley during the incident. U.S. Circuit Judge Richard Sullivan concluded that MSG's actions of issuing multiple legal hold notices and using third-party archiving software constituted reasonable steps to preserve ESI under FRCP Rule 37E. He also accepted the MSG expert's conclusion that a software malfunction was responsible for the data loss. Judge Sullivan explicitly noted that Rule 37E is inapplicable when the loss of information occurs despite the party's reasonable steps to preserve, such as when ESI is destroyed by events outside the party's control. In denying Oakley's motion for sanctions, Judge Sullivan also rejected Oakley's arguments, including the selective preservation theory, which was undermined because the glitch affected 79 other legal matters, not just Oakley's. Furthermore, the emails of CEO James Dolan, whom Oakley considered a crucial witness, were not lost. The theory of deliberate deletion of 4 mailboxes was unsupported by evidence, with the MSG expert testifying there was no evidence that an individual went in and actively deleted those inboxes, and the PowerShell theory was dismissed as speculation, directly contradicted by the MSG expert's testimony that the observed data loss was not feasible even via PowerShell. Judge Sullivan also rejected Oakley's spoliation claims regarding 2 other types of ESI, which are mentioned in the blog post if you want to check those out. So Judge Peck, what could Oakley have done, if anything, to make a better case for spoliation sanctions?
Well, he could have shown, if there was indeed evidence of it, that employees did email or they did text about Oakley's removal from the garden, either by showing some such emails or texts were produced elsewhere in the production or through deposition testimony. He could have made a preservation request for texts and not just email, which Judge Sullivan mentioned. And it probably didn't help his case by focusing on the Dolan binder, which MSG showed very convincingly with Bates number description that those documents outside of the binder were produced individually as individual documents. Also, I guess the last thing I would say is judges take into account a party's overall conduct in the litigation, and the matter we discussed last month with Oakley's own spoliation probably did not help how Judge Sullivan viewed him on this as well.
Right. Yes. Actually, yeah. And actually, we discussed it 2 months ago. But yes, great.
Seemed like it was just last month. What can I say?
Right. I know they run together after a while, don't they? Right. So yes, great segue, because Mary, this ruling occurred actually on the same day as that ruling we covered back in August, where Judge Sullivan issued sanctions against Oakley for his quote unquote stunningly derelict attempts to preserve text messages. So do you think Oakley's spoliation motion could have been designed to take attention away from the spoliation motion against him?
Oh, do you think? Maybe? Yeah, I think it looked very much like he wanted to dirty MSG up. But MSG had competent counsel and wonderful experts, and they relied on the current rules, not the old 37E where, if you made that kind of a technical glitch, you could still get sanctions. That's not the case these days.
Yeah, at least under 37E, as we'll kind of talk about in the next case. But yeah, definitely the timing is certainly curious, to say the least. So Tom, what do you make of the explanation of a systemic technical glitch in Microsoft Purview by MSG? Should Purview customers be worried about the product's ability to adequately preserve their data?
Well, I think we're going to have to go to the video to see if this was a flagrant foul or just a mere technical foul, actually.
There you go.
Because this is a great example of when your opponent hires a forensics expert to come in and give technical testimony or issue a report about what they find, it behooves you to get one of your own and not just rely on legal argumentation. And especially since the crux of this is where the loss of information, did the parties take reasonable steps to preserve? So the litigation hold was applied, but in this case, and I think everyone agreed on these facts, the mailboxes in question had multiple overlapping retention policies. And one of those policies had a shorter retention time than the other. So according to the expert, it was, quote, prioritized incorrectly by the system, end quote. I would disagree with that. It prioritized it the way it prioritizes things in all Microsoft systems. And Microsoft technical documents talk about this. They say that Exchange uses a hierarchical policy evaluation model where retention tags and policies can conflict if they are not carefully scoped. How do you have multiple mailboxes with differing or overlapping retention policies on them? Now, I suppose the system glitch could have been that when you went to apply the second hold, the second retention policy, maybe it should have come up with a warning that said, hey, you've already got one here. Take a look at this. But, the fact of the matter is they applied multiple retention policies to multiple mailboxes with different time frames on them. I don't think that's a systemic glitch. I do a lot of work with Purview, and I work with a lot of clients who use it and some consultants and even people at Microsoft. Saying it's a systemic glitch makes it sound like it's a bug. I'm calling user error on this, and we're applying a flagrant foul. I'm sorry. Now, I will say in Madison Square Garden's defense, and the judge correctly pointed out, did this rise to the level of bad faith? Does incompetence rise to the level of bad faith? You didn't know what your system was doing. Probably not. And since there's no bad faith, no sanctions, and he correctly pointed out, Mr. Oakley didn't show any prejudice. He didn't argue that even if they did do this wrong, where's the prejudice to me? So there was a real problem there in their pleadings.
Yeah, no, a great discussion of kind of what really could have happened here, certainly as was noted in the case, there were this issue affected 79 other legal matters. So yeah, clearly multiple holds and preservation time periods were applied. So yes, definitely a very convoluted and challenging scenario, one that I think a lot of organizations dealing with Microsoft Purview who have a lot of litigation going on might be dealing with. So
this is not for the faint of heart. Microsoft Purview is not for the faint of heart. I should also say there was a second level of problems here in that they converted everything to PDF, and I think Mike Berman had a great column or blog post on that very issue. But that's separate from the underlying issue of conflicting retention policies.
Yeah, no doubt. And a question, I'm not sure if we have the information, but one of our audience members is asking, how did they apply it? Was it through Purview eDiscovery Premium or some other way? I don't know if you.
I do not know the answer to that. I did not see that in the expert's report what the exact manner of the retention policies was. I can try to find out.
Yeah, it would be interesting to find out because obviously those are considerations as well. The premium version gives you certain capabilities, the lower versions don't. You would think of an organization as large as MSG Networks might be using the premium version, but we can't say that for sure. So definitely an interesting case and an interesting situation that organizations need to be kind of mindful of. So very interesting case, and we'll move on to another technical glitch case. And those technical glitches aren't limited to just Purview or M365. They can also happen to third-party archival systems supporting M365 as well, and that's what happened here, where Match Group provided additional materials to the FTC 3 months after the discovery period closed, consisting of emails that hadn't been previously disclosed. They acknowledged that the discovery was responsive to the FTC's request, and stating that its failure to produce the material during the discovery period was the result of a technological glitch in its archival system, which preserved files from M365 and advertised its interoperability with M365. They discovered that because they did a search on another matter and got a lower count than they were expecting, which then surfaced the issue. Using a different backup system to identify any responsive documents that had been missed, Match Group found and produced 37 additional documents to the FTC in August 2023 and 450 additional documents 2 months later. Match Group didn't oppose the FTC's request for extension of its page limits on the reply brief and agreed that the FTC could use the late produced documents in an appendix to the reply, but the FTC still moved for sanctions, proposing that the court prohibit Match Group from using the late produced documents at trial, either affirmatively or in response to the FTC's use of them. Texas Magistrate Judge Brian McKay found that Rule 37D1A2 does not apply to the circumstances present here because it applies to a complete failure to provide any response to discovery at all. He also stated, the court concludes that Rule 37C1 allows the company to avoid exclusion by showing that its failure to produce was substantially justified. Match Group asserts that it reasonably relied on the archival system to collect documents for production, and the court agrees, also noting Match Group's representation that it produced more than 300,000 documents in this case during the discovery period. But Judge McKay ruled sanctions are appropriate under Rule 16F1, stating Match Group acknowledges that it failed to produce documents until after its deadline to do so. That is sufficient to find a violation. Considering the four harmlessness factors engaged in connection with sanction under Rule 37C1 holistically, Judge McKay said, the court finds that Match Group has not shown that its late production was harmless in all respects. Its failure to produce the documents did not materially impact the merits of the FTC's summary judgment motion, but it did prevent the FTC from questioning certain witnesses about documents that are probative of the FTC's claims. While finding that the sanctions were appropriate, Judge McKay rejected the one-sided exclusion the FTC requested, whereby it may use the late produced documents at trial, but Match Group would be precluded from explaining or otherwise responding to them. Instead, he allowed the FTC to conduct additional limited discovery on the late produced documents as follows. The FTC may depose up to 3 individuals, each for no more than 2.5 hours. The scope of these depositions is limited to matters directly implicated by the late produced documents. So, Mary, do you think the FTC could have done anything more to convince Judge McKay to issue the one-sided exclusion sanction they requested?
Well, yes, I do. I think that the standard that they put out there is that their reliance on their archival system was substantially justified, if they could show that it wasn't reasonable to rely on an archival system without testing it first, I think that would have given them a little bit more juice. They also went back to the well, to their backup systems and their alternative systems, and they did their best to supplement the production. The Match Group did. So then you would need to maybe say, well, why didn't you do that in the first place? And you should have, you should have better control of your evidence from the get-go.
Yeah, certainly a valid consideration, and absolutely that could have been part of the argument. So, hey, Tom, here we are with another technical glitch. The last case, it was a technical glitch with Purview that caused emails not to be preserved. This time, it's an archival solution designed to work within 365 that caused documents to be missed in retrieval. So what advice do you have for our audience to ensure that their systems are preserving and retrieving the correct documents?
It's amazing that they both use, two different people use the same term. Almost like these IT folks talk to each other. Right?
Yeah. Seems interesting, right? Yeah.
Technical glitch seems to be like the new IT boilerplate language. Well, something went wrong and it was a technical glitch. I'm bothered by, again, no, like the last case, no really in-depth explanation of what that meant. But using the wording from the Microsoft data earlier, even though it wasn't a Purview issue, you need to scope out your systems. And as Mary pointed out, second on my list would have been, you need to test them. If you're going to implement something like this, you should be doing all the things that they did after the fact, as Mary said, ahead of time. That should be part of your scoping and testing of a system that you're gonna put into place. And talk to other people who use the system. Don't just take the word of the company that it does a good job. Try to find some other people who've used it. IT people do have ways of talking to each other. They go to ILSACon. They have user groups. Get with some of your colleagues and find out if that system has been used someplace else. And then finally see if there's any independent evaluations or reviews or studies or reports about the system in question. This is all also, I left it to this case to bring this up. It's going to be magnified by the fact that Microsoft is, of course, for those who don't know, be afraid, be very afraid. Microsoft is shifting Purview into Copilot for purposes of eDiscovery. They're making Copilot the blanket product, if you will, for eDiscovery. So there's going to be some shifts in how they do all of this. So I think it behooves you even more to find out what's going on with programs or new programs that might be used.
Yeah, absolutely. We lost you there for just a split second, Tom, but I think we got the gist of what you were saying. So,
Copilot, they're shifting to Copilot, and
I think that's a great point. And obviously, one of the considerations for the shift into Copilot and the involvement of Copilot and everything Microsoft is the AI artifacts it's generating and the discoverability of that. So that's a whole nother issue, another can of worms. But in this case of the archiving solution, ate my homework. It's left aside for the moment, at least in this regard.
I've got a call tomorrow with somebody at Microsoft to ask about all of those questions, and hopefully I'll have something to report back by the end of the week, or write it up and get it for you within the next week or so.
We'll cover the AI issue in 6 months or so when we finally get a case that deals with that.
Yeah, right.
Yes,
right.
Yes. We certainly will.
Maybe it'll be the Madison Square Garden case.
Well,
we're going to overtime.
Right, exactly. There you go. Yes. All right. So, Judge Peck, given that Judge McKay found the failure to produce was substantially justified, are you surprised that Match Group still receives sanctions? And do you think they could have done anything else to convince Judge McKay not to sanction them?
Well, first of all, in the language of 37E1, even though this was the decision under 60 and F, ordering depositions is not really a sanction. It is a curative measure.
Right.
So that's one thing. And it was a very small curative measure, 3 depositions, 2.5 hours each maximum. As to the second part, that Match Group was ordered to pay the, quote, reasonable costs associated with the depositions, close quote. I mean, that is basically, small change. The court reporter fee, the videographer fee, if these were videotaped depositions, not that this sort of order what was appeal. Well, it wasn't appealable, but it was a magistrate judge's decision. Objections could have been filed with the district judge, but the cost of doing that would well have exceeded these limited costs that they were required to pay. So if you want to call it a sanction, it's a very, very small sanction.
Yeah, and honestly, yeah, I mean, it's understandable, but yeah, I like the term curative measure because that's what it comes down to here, is just addressing the harm resulting from the late production. So interesting case, and we'll be interested to see if we get any more of these technical glitch type of cases in the future. But we'll move now into the Judge Peck half of the webinar, as all three remaining cases were suggested by him. And in the words of the great American philosopher Meatloaf, 2 out of 3 ain't bad. But of course, that depends on which side of the 2 out of 3 you're on. Here, Amazon attempted to claw back 3 categories of documents it had previously provided to the plaintiffs. The parties stipulated to an ESI order, which contained a 502D component and was entered by the court. The first category in dispute was documents clawed back after privilege re-review, where plaintiffs contended that the ESI order and Rule 502D do not permit the clawback of documents that were intentionally disclosed after a privilege re-review. Amazon argued that the ESI order's language, inadvertent or otherwise, allows for clawbacks of any disclosure, including conscious but mistaken ones, unless they were used for strategic benefit. Washington District Judge John Chun sided with Amazon, finding the ESI order's language to be decisive. The order explicitly states that Rule 502B's provisions, including the requirement of inadvertence, do not apply. This gives Amazon a free hand in clawing back documents. So, score 1 for Amazon. The second category was documents produced in the pre-suit investigation, where plaintiffs contended that an agreement from April 2024 did not retroactively apply the ESI order, which was entered later, to documents produced during the FTC's pre-suit investigation, meaning the stricter Rule 502B standard applies. Defendant contended the agreement stated that investigation-era documents were deemed produced in the litigation, meaning they should be treated like any other production and fall under the ESI order's protection. Judge Chun found the agreement's language, deemed produced in this litigation solely as a matter of convenience and in the interest of efficiency, was not a concrete directive sufficient to supplant Rule 502B. Because the agreement did not explicitly state the ESI order would apply retroactively, the default standard of Rule 502B governed these documents, of which Amazon failed the first prong because it did not claim the disclosure was inadvertent. So score 1 for the FTC. The tiebreaker category was documents discussed in depositions, where plaintiffs argued that Amazon waived privilege over 2 documents by permitting questioning on them and waiting hours after their introduction before objecting. Defendant responded that the objections were ultimately raised before the depositions concluded, making them valid and timely, with formal objections lodged within 3.5 hours at both depositions. Judge Chun found that objections made a matter of hours after a document's introduction, but still during the deposition, are considered timely and do not constitute a waiver. So Amazon prevailed on 2 out of 3 categories. So, Tom, for the documents in the pre-suit investigation, Judge Chun noted that Amazon did not claim, let alone demonstrate in its briefing, that its initial production during the investigation was inadvertent. Did Amazon drop the ball on this category?
Yeah,
Tom?
and they just kind of overlooked that. I mean, as you just quoted, they did not claim, let alone demonstrate, that the production was inadvertent. So since they didn't say that it would, since the agreement did not explicitly state the order would apply retroactively, then the default standard of 502B governs, and they didn't do it. So I'm guessing that was inadvertent, but But a drop ball is a drop ball. You know, it's traveling. Sorry.
Oh, back to the basketball again. There we go. Yeah. Well, all right. Well, I'm going to pass the ball up court to Judge Peck for the next question. Judge Peck, despite the fact that the case hasn't entered Rule 502D order, there are disputes regarding multiple categories of clawbacks. So do you think this is because the Rule 502D order isn't comprehensive enough, or could it be due to some other reason?
Well, I think parties can argue about anything and everything, and usually will. One of the interesting things here is Judge Chun is the same judge who decided in the DaCosta against Amazon case that we discussed in one of our recently prior webinars. I'm not going to guess whether it was 1 ago, 2 ago, since I obviously dropped the ball on that previously. You know, so I think there is a certain reluctance in the Ninth Circuit and the district courts within it to give full effect to 502D orders. But, you know, what could Amazon have done here? They could have added a provision in the 502D order that it applied retroactively to pre-suit documents. Not clear if Amazon didn't even think about that and didn't request it, or they couldn't get the FTC to agree to it and didn't want to have a dispute before Judge Chun on the 502 issue. Could have also had language about ability to claw back documents used at a deposition if the clawback request was made within X hours or Y days after the deposition. We saw that in a case, the name of which, of course, I'm blanking on, but it was one a while back where the parties came to the judge with disputes about what should be the extra provisions in the 502D order. And the party who wanted the 502D to apply to depositions convinced the judge that as long as it wasn't an open-ended time period, but I think the judge agreed on 30 days after the deposition that you can make a clawback if you didn't realize at the deposition that the document was indeed privileged. But look, you know, if you start dealing with every possible nuance without knowing what's going to happen, the 502D order goes from something very short and sweet into, you know, if this, then that, if Y, then Z, which then could have, you know, the reverse effect if the opposing party or the judge said, well, you took account of these 6 variants, but ours is not one of them, therefore you've lost the 502D protection. My mind is one should always extend 502D to, you know, its logical effect of limiting the possibility of waivers without clawbacks.
Yeah, absolutely. Yeah, I mean, you know, Judge Peck, we've only covered like some 350 cases over the past 5+ years, so I don't understand why you don't remember every exact one. I know which case you're talking about. I think it was last year where that dispute occurred over the use of the 502D in depositions. So yes, and the fact that, you know, Amazon may have made a couple of mistakes here, even our audience is getting into the mix saying you've got to work the double dribble pun in there. So you know, thanks for you know, adding to the discussion here. So I mean, let's face it, Mary, these disputes don't happen unless privileged documents are disclosed in the first place. So what can parties do to minimize the disclosure of privileged documents and avoid having to request these clawbacks?
Yeah, well, I think you know, Judge Peck is right on the money with the negotiation. I actually thought these 502D orders were very broad, but clearly you have to draft carefully, especially noting what jurisdiction you're in. But then for the mechanics of it, it all starts at the beginning to have a very rigorous privilege design effort right at the start of the matter, and document it, train to it, certainly gather the universe of legal domains the person or organization worked with for screening of the emails, then get to the off email communications and the custodian interviews. And at the processing stage, you can mark those documents as potentially privileged and give them a higher level of care. But if you have a review once and pollinate many review, so you're reviewing like inclusive threads in only one instance, and then you basically repopulate everything at production, you're going to want to have another very rigorous quality control step for privilege with trumping rules, if you will. If this, then that, and be very careful about what you send out.
Yes, indeed. I prefer superseding over trumping, but that's just me. Yes, absolutely. Obviously, that's the best way to avoid disputes over clawbacks. And definitely some great best practices for doing so. So let's get on to our next case. Which may be the shortest case we've ever covered. In fact, this slide includes pretty much the entire case and even the 2 footnotes. Go figure. So here the parties sought entry of an order adopting the parties' ESI stipulation, which was attached to the joint order. Florida Magistrate Judge Samuel Horvitz stated, upon review, the motion, which contains only a passing reference to FRCP Rule 26C and does not contain a memorandum of law as required by Local Rule 301A, fails to establish by citation to legal authority or otherwise that the court's entry of an order adopting the ESI stipulation is necessary or appropriate, particularly in light of the parties' agreement to the procedures set forth therein. Absent authority demonstrating that entry of the ESI stipulation by the court rather than private agreement amongst the parties is proper, the motion is due to be denied. Otherwise, if a dispute arises regarding ESI protocols or agreements, then after appropriate conferral, enforcement may be sought with a properly supported motion and memorandum of law. So he denied the motion without prejudice. But he also, as I mentioned, included 2 footnotes in his order. The first said, even if the parties were to file a properly supported motion showing it appropriate to enter an order adopting an agreed ESI protocol at this time, they must ensure that their proposal is clear and internally consistent. The second footnote said, though unclear, the undersigned notes that the ESI stipulation includes provisions arguably implicating Federal Rule of Evidence 502. However, the motion does not mention Rule 502, nor does the ESI stipulation, and is insufficient to justify any corresponding relief. Moreover, the ESI stipulation appears to be unclear and ambiguous. If the parties intend to seek a non-waiver order pursuant to Rule 502D, they must expressly so state in any renewed motion, must better explain and properly support the basis for any such request, and must make any necessary edits to their stipulated proposal. To be sure, Rule 502D orders are often entered on request, but a Rule 502D order remains discretionary. The parties should also consider that, even if authorized, the protection of Rule 502D is limited to material covered by the attorney-client privilege or work product privilege and will not be expanded beyond that narrow scope. So Judge Peck, Judge Horvitz noted in the second footnote that neither the motion nor the ESI stipulation mention Rule 502, even though the stipulation includes provisions arguably implicating the rule. Is the intent to seek a non-waiver order pursuant to Rule 502D without filing the actual order bad lawyering?
Yes. And since this is short enough, I can, we have the time. I'll go a little further than just that one word. I'm scratching my head on what they did here. It's one thing if you're doing a report to the court under Rule 16 that the parties will be seeking a 502D order. Okay, that's, not the order. It's not intended to be the order. But this, the proposed order with a stipulation attached, to me, that would have been the 502D order. And so it is very puzzling that they didn't, use the magic words, Federal Rule of Evidence 502D, anywhere in either document, at least from what I could tell from reading this. But this is also part of I guess I'd call it a mini trend of courts not wanting to convert a stipulation into a court order, saying that if the parties stipulated to something in writing, that's good enough until somebody violates it. And wearing my lawyer hat, I prefer a ESI stipulation to be just that, a party stipulation, and not a court order, because of the adverse effect that there could be from violating a court order, so that something that otherwise would have gone under 37E would become where you'd have to show the various steps in 37E that we just talked about. If it was just a violation of a court order, then under 37A or B, there could be enforcement just for the violation, regardless of the prejudice, et cetera. So I think from a lawyer perspective, I prefer this approach. From a judicial perspective, there is somewhat more of a pushback saying, don't just toss something in front of me knowing that if it's agreed to, I'm going to sign it without reading it. That's not going to happen.
Right. Yeah, for sure. So, so I was about to ask Mary if she thinks judges try to avoid entering ESI protocols and ESI stipulations as orders to avoid downstream motions for sanctions. So here's your chance to agree or disagree with Judge Peck, Mary.
I absolutely agree with Judge Peck, and I also think the words internally consistent to describe what was put in front of the judge. I mean, they're not going to want to turn at something that's like a mess into an order. And some of the protocols and stipulations are a little bit technically impossible or just very vague. So I think there might be some avoidance on that as well.
Yeah, couldn't agree more. So, Tom, if the parties have an ESI stipulation they're comfortable with, do they even need to enter it as an order?
Well, no. Again, as the judge pointed out, probably not, but it all seems to revolve around how comfortable are you with your agreement with the other side. A lot of times in matters that I've seen or been involved with, the parties are not getting along. I was involved in a big one here in New Orleans, the Signal case, where the judge said, draw up an order. I'm sick of you guys squabbling about all of this, and I want you to prepare a proposed order, and I'll review it, and we'll enter it and nip this in the bud. But if you've got some good cooperation, Judge Rodriguez, the Western District Justice, of course, had a webcast about this a while back, and he made the same point that Judge Peck just did. Be clear about what you're talking about, and otherwise you're going to start. You're talking about technical issues that are going to get to be overly technical too soon. But the other thing I've seen is, much as in this case, it seems like people are confusing a 502D with a stipulation regarding items that are in the terms of the 502D, and it's almost like they're going for a 502D light in the agreement. And then you're just fumbling and stumbling around. Pretty soon, it's like an eDiscovery double dribble. You lose control of everything, and the ball goes out of bounds, and you turn it over. So yeah, I'm a big fan of what Judge Peck said. Do a nice report to the court about what you're going to do. If you're going to do a 502D, say, yeah. And one of the things we've agreed on is we'll submit a 502D for your signature.
Yeah,
there you go.
Let me just clarify what I said so I'm not misleading anyone. The rest of an ESI protocol has the same effect in a stip and a court order. If you don't get the 502D so ordered by the court, then it is only protective as between the parties to the case to
Right.
get the further protection that it is for all purposes, all cases, anywhere in federal or state court, even against other parties. You need the court to have signed off on the 502D.
502. Yeah, great point. Great point.
Yeah,
Thank you.
absolutely. Yeah,
Thank you.
and that is, I think Judge Peck has said not getting the 502D is tantamount to malpractice. So I think that's always a good thing to remember. We'll move on to our last case here, where the parties negotiated an ESI protocol and reached an agreement on all issues except one, email threading. This led to cross motions for the entry of their respective proposed ESI protocols. Defendant argued for an ESI protocol that would allow it to suppress non-inclusive emails. This would reduce the volume of documents to review and produce, thereby lowering hosting costs and increasing the speed of completion. Defendant asserted this was an industry standard process that would provide plaintiffs with all substantive information. Plaintiffs opposed email threading, arguing that suppressing non-inclusive emails results in the loss of their associated metadata. This loss, they contended, would render their organizational and data visualization tools non-functional, hindering searchability and forcing them to rely on less efficient manual text searches. They argued this violated the requirement under FRCP Rule 34B for ESI to be produced in a reasonably usable form. Defendant offered to write a script that would generate a new field populated with metadata relating to the participants and dates of non-inclusive emails, but plaintiffs argued this new field would not include all metadata and would still prevent their use of data visualization tools. Considering the usability of the produced data, Illinois Magistrate Judge Young V. Kim stated, the court sides with plaintiffs. First, plaintiffs have requested production of the emails as they are ordinarily maintained, which is the clearest default form of production set forth in Rule 34. But defendant proposes producing ESI in a form that deviates from the Rule 34 norm from plaintiff's request and without demonstrating that its proposed alternative is reasonably usable as required. This is insufficient to justify setting aside plaintiff's proposal, which indisputably complies with the rule. Indeed, while defendant argues that email threading does not alter content or metadata, the fact that defendant must program an additional field to capture the metadata at issue supports plaintiff's argument that withholding non-inclusive emails results in a loss of metadata. The fact that the metadata plaintiffs seek can be provided in an additional field does not make it equivalent in terms of searchability and usability. Furthermore, here plaintiffs have articulated a specific need, albeit barely, for the lost metadata in its ordinary form. Judge Kim also noted that despite the fact that the defendant provided an expert declaration to support its position, defendant provides no analysis of the proportionality factors in Rule 26b1 beyond unspecified claims of substantial burden that the potential scope of discovery will exacerbate. Non-specific or speculative claims are insufficient for the court to weigh defendant's burden against the remaining proportionality factors in Rule 26b1. So Judge Kim granted plaintiff's motion and denied defendant's motion without prejudice, but opened up the possibility that more specific evidence from the defendant regarding burden could possibly change that ruling. So Mary, do you agree with the defendants that suppressing non-inclusive emails in review and production is an industry standard process that would provide plaintiffs with all substantive information?
Well, I wouldn't call it an industry standard process. I'd call it an advanced practice. And I'd say, sophisticated litigants exchanging information with each other might decide to do something like that. But many eDiscovery software platforms won't be able to parse that, those inclusive emails. So I'd say no, and you already said some of the reasons. Their visualization tools, certainly if they want to do some date range data reduction, that will make that harder because the dates won't be on a separate line in order to exclude them. So I would say no.
Yeah, yeah. That's well
in conclusion,
put.
In conclusion,
Right. In conclusion, I would say no. Right? I mean, I think that suppressing emails for review is pretty standard because you have the email thread capability, and you have the ability to say, okay, this email's in the thread is relevant, so all of you can mark them all relevant with the push of a button in many review platforms. But I don't know about production being an industry standard process. I often see that they continue to be produced for that very reason. So Tom, Judge Kim noted that even though it included a declaration from a defendant expert, defendant provides no analysis of the proportionality factors in Rule 26b1. Do you think that's an oversight, or do you think the real issue is that the increased costs in hosting, review, and production are negligible?
I think that substantial burden has become one of the standard boilerplate language arguments that litigators are using, right up there with industry standard process. I don't know if that qualifies as an oversight, but the judge was clear. What did he call it? A non-specific or speculative claim.
Right.
You can't just make a statement like that, throw it out there, and leave it hanging. You got to give me some numbers to hang my hat on.
Yeah, and my suspicion is they don't have the numbers to provide because it's really not.
They don't have the numbers. Yeah.
It's not that significant. I mean, because the non-inclusive emails typically don't have attachments, with occasional exceptions. So usually the increased cost of hosting isn't that big. Review, like I mentioned, is mark all in the thread responsive if any are responsive, and production, of course, then you're just producing whatever's marked responsive. So to me, it seems like a non-issue from a burden standpoint. So I kind of feel like maybe they didn't provide specificity because there wasn't really anything to provide.
Because there wasn't anything.
Wasn't much of a burden to begin with. So Judge Peck, Judge Kim made a point of noting that plaintiffs have requested production of the emails as they are ordinarily maintained. If more parties use that language, do you think production of native files instead of the traditional TIFF plus or PDF plus productions would become the standard?
Probably not. I know our friend Craig Ball believes that native production is the way to go. The Sedona Principles, however, supports the TIFF plus, PDF plus production. The parties want to be able to date stamp their production. They want to have confidential stamping on the documents, redaction, all of which from a non-technical person, so Tom or Mary can tell me I'm wrong, that the TIFF plus approach is better generally, and really that can be handled without regard to the email threading here. You produce a TIFF plus of whatever it is you're producing. And if that means each of the lesser included emails is separately produced after being reviewed in bulk, as Tom and Mary said, that won't be a problem. And perhaps what the defendant should have done here was actually objected to the request that it be produced in the form ordinarily maintained, and provided that there will be, that it will do something different. Maybe that is how this got in front of the court quickly, maybe not. I think the biggest problem in producing each of the internal emails is, as Rachel mentioned in the questions here, and that is inconsistent redactions, where different reviewers perhaps are reviewing the lesser included emails, and one on the email chain redacts in one way, and the one dealing with the individual email redacts it differently, etc. So that is a big problem, but that's really separate and just a workflow and QC issue than how it is produced.
Yeah, absolutely, and that definitely does add some complication to the because if you're redacting it in one, you have to redact it in all the others. It appears to be consistent and does open the possibility of inconsistency. Great point. So yes, we did have a couple other questions. Judge Warshawski asked, "Isn't reasonably calculated still used widely in states?" I Googled it, and it certainly seems like that's the case. Of course, that was from an AI overview, but that was certainly my understanding, that the reasonably calculated to lead to the discovery of admissible evidence language is still in many state rules. Judge Peck, your thoughts on that?
You and Google there say something. I can't argue with it, but of course you got to use the rule that you're in front of. If you're in front of Judge Warshawski in the old days in state court, and state court allows that language to be used and didn't change it, then sure. But if you're in federal court, get with the current rules.
Yeah, absolutely. And I think we may have answered the question, Rachel's question on the previous case about won't that impact applicability in other proceedings under Rule 502D. I definitely think we addressed that as part of that discussion. So with us at the contacts page, we do have a date for our next webinar, which is yet another Manic Monday, 4 weeks from today on November 17th. Let's face it, the Bengals haven't gotten this much promotion since the 80s. So
we got to pick another day. We got to pick another day, Doug. My heels are starting to kill me.
There you go. Indeed. So with that, I'll say thanks to Mary, Tom, and Judge Peck as always, and I'll turn it back over to you, Mary, to close us out.
Thanks, Doug. And so we'd like to thank you, Doug, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. Our thanks to the EDRM community for your kind attention. If you enjoyed today's presentation, show our faculty some love, explore the resources at the bottom of your console, and share an emoji or reaction. And we look forward to seeing you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks
folks.